Welcome to S&C's Critical Insights. I'm Annie Ostrager, a partner in the firm's litigation group and one of the co-heads of our employment law group. Joining me today is my partner, Nic Bourtin, the head of our criminal defense and investigations group.
Hi, Annie. Great to join you.
Great to talk with you as always, Nic, to continue our Critical Insights series on a range of developments related to whistleblower programs which are impacting our clients. Sabrina Solow, an associate in our litigation group, is also back to continue to moderate this series. In our previous episode, Camille Shields and Kyle Mack, partners in the litigation group, discussed the new Antitrust Division Whistleblower Rewards Program. If you missed that episode or our introductory episode to this series, you can find them in our Critical Insights library. Today, we're going to discuss the DOJ Criminal Division's corporate pilot program, including recent changes to that program under the new administration. And then we'll talk about cases involving the False Claims Act qui tam provision. As I previewed in our introductory episode, the False Claims Act is currently getting a lot of attention. And then we'll touch briefly on the whistleblower provision of the 2020 Anti-Money Laundering Act. So Sabrina, I'll turn it over to you to get us started.
Thanks, Annie. And it's always great to talk with you both. We've got a lot of material to cover today, so let's jump right into a discussion on the DOJ Corporate Pilot Program. Nic, could you please give us the background on this program?
Sure. Around this time last year, in August 2024, President Biden's DOJ launched a 3-year corporate pilot program to encourage whistleblowers to come forward and report certain types of alleged corporate misconduct. The program compensated whistleblowers who came forward with original information, so long as the information was not already covered by another whistleblower program, and so long as it led to a successful forfeiture action. It was designed as a gap-filling program meant to plug what the DOJ viewed as gaps across other whistleblowing regimes. In rolling out the program, DOJ explained that it wanted to incentivize those with information about corporate criminal wrongdoing to report original information about criminal conduct that might otherwise go undetected or be hard to prove. And relatedly, the program was meant to motivate corporations to create more robust compliance programs.
What sorts of misconduct does this pilot program target?
Well, by its terms, the original program required that tip information relate to one of 4 areas of corporate crime. First, violations by financial institutions, including things like money laundering or AML violations. Second, foreign corruption and bribery, including FCPA violations, among others. Third, domestic bribery or kickbacks. And finally, healthcare fraud against non-public insurers.
Interesting. Have those priorities shifted?
I would say a number of the things Nic just covered remain enforcement priorities, at least as we're seeing in our practice, but likely as no surprise to many of our listeners. Under the current administration, the DOJ has expanded the pilot program to cover customs and tariff fraud, federal immigration law, sanctions offenses, and violations relating to the support of terrorism or cartels, all of which are areas of enforcement priority.
Thanks. Apart from subject matter, are there other requirements of the pilot program that we should highlight?
So Nic already mentioned that the information provided has to be original, meaning that the information is derived from the individual's independent knowledge or independent analysis. But interestingly, information does not need to be the catalyst for the DOJ's investigation, meaning that even when DOJ has already opened an investigation, an individual can still provide the DOJ with original information about the conduct that's under investigation. And if the information significantly contributes to any ultimate resolution, the individual whistleblower may receive an award as long as there was a forfeiture of more than $1 million. The information provided also has to be voluntary, And the relevant guidance clarifies that that means that it can't be information that was provided in response to a request or a demand, even if the individual is responding to the request voluntarily, so not in response to a subpoena. The information also has to be truthful and complete. So the individual has to have provided all the information relating to the alleged misconduct, which would have to include misconduct in which the individual participated if they are aware of any such conduct. And when submitting information through this program, the whistleblower has to declare under penalty of perjury that the information is true and correct to the best of that person's knowledge. The individual seeking to act as a whistleblower will have ongoing cooperation requirements, which could include providing testimony, producing relevant evidence, or working in a proactive manner under the supervision of law enforcement in furtherance of the ongoing investigation.
Thanks, Annie. Nic, what sort of recovery is at stake here?
Well, the recoveries can be very large. If the department brings a successful forfeiture action, the whistleblower can receive up to 30% of the first $100 million in net profits forfeited, up to 5% of net proceeds forfeited between $100 and $500 million, but nothing beyond that $500 million cap. The award calculation is pretty technical, but there are some interesting factors from the perspective of a company's compliance procedures. So in calculating the eventual award, DOJ says it will look in part at the degree of assistance provided by the whistleblower. And as part of that determination, it will look to the timeliness of the whistleblower's report to the DOJ or an internal compliance system. The department also says that whistleblowers' participation in an internal compliance system is a consideration that will increase an award. Meanwhile, if the whistleblower interfered with the internal compliance system to delay detection, that will decrease the award. These provisions suggest that many whistleblowers proceeding under this program are likely to raise an internal alarm first before going to the DOJ. The DOJ included these provisions at the urging of many in the bar in order to encourage whistleblowers to go first through their internal compliance channels, which we all hope will lead to more effective internal compliance programs overall.
Let's shift to another whistleblowing topic that, as Annie mentioned at the outset, has been in the news recently. This is the qui tam provision of the False Claims Act. For more details on this provision, please check out our Critical Insights library. Annie, at a high level, how does the FCA qui tam provision authorize whistleblowing?
Qui tam suits generally are whistleblower lawsuits that a private individual, called a relator, can file on behalf of the government to recover funds in connection with a federal program or contract that have been lost as a result of fraud. The government, not the relator, is considered the plaintiff, and the government makes the determination at some point during the course of the litigation whether to step in or seek to dismiss the case, and we'll talk about that a little more in a bit. But qui tam cases are commonly brought under the False Claims Act, and a successful relator in a False Claims Act qui tam action can receive up to 30% of the reward and is also entitled to attorney's fees and costs if ultimately successful.
Thanks, Annie. Nic, have there been any important qui tam cases lately?
Yes, for sure. We should absolutely discuss the DOJ's June 25th, 2025 dismissal of a then pending qui tam case called United States XREL Vermont National Telephone Company versus North Star Wireless LLC. There, the relator alleged that North Star Wireless and other related entities had fraudulently obtained FCC bidding credits. The relator brought the motion originally in 2015. After nearly a decade of litigation, the DOJ finally filed a motion to dismiss on the ground that the case would not vindicate government interests. The court found persuasive that DOJ need not disprove the relator's case before it can dismiss, and that there is no quantitative threshold the government's burden must exceed before it may move to dismiss, because determination of the government's resources is the government's judgment call. It's pretty remarkable that the DOJ decided to reverse its position and dismiss this case in 2025. Back in 2023, the court had declined to dismiss the case, citing in its rationale that the United States had at that time opposed the dismissal of all the claims. So in other words, the relator there had spent 10 years of time and money pursuing the case, only for the government ultimately to intervene and dismiss it.
Annie, what should we make of the government's decision to dismiss this decade-old case?
So in addition to the points Nic covered, I think it's important to note that this decision also spotlights the controversy surrounding the constitutionality of the FCA's qui tam provision. A couple of years ago, in July of 2023, our partner Tracy Rochelle High and I discussed this issue when the Supreme Court's Polanski decision came down and confirmed the government's ability to dismiss qui tam actions so long as the government offers reasonable arguments that the burdens of the litigation outweigh its benefits. But as we also discussed at that time, Justice Thomas's dissent argued that the FCA's qui tam provision may violate Article 2 of the Constitution by allowing private citizens to litigate on behalf of the government without sufficient oversight. Justice Kavanaugh's short concurrence, which was joined by Justice Barrett, echoed those concerns. Since then, there's been further litigation addressing the constitutionality of the FCA's qui tam provision. So this past February, in Wisconsin Bell v. United States on behalf of Heath, Justice Kavanaugh wrote a concurring opinion joined by Justice Thomas, in which he reiterated that qui tam provisions raise substantial constitutional questions under Article 2. As in his Polanski concurrence, he articulated the view that in an appropriate case, the court should consider the competing arguments on the Article 2 issue.
That's a clear signal. Who's taken the hint so far?
Well, we've seen defendants take up the court's skepticism of the provision's constitutionality. So, for instance, Jansen is asking the Third Circuit to find that the FCA's qui tam mechanism is unconstitutional and to vacate a $1.6 billion judgment against it. In its appellate brief, Jansen noted that 3 justices of the Supreme Court, Thomas, Kavanaugh, and Barrett, have all articulated concerns as to the constitutionality of FCA qui tam actions. Recently, DOJ filed a brief, partly as intervener and partly as an amicus in support of neither party. In its brief, the DOJ argued that FCA qui tam suits do not violate Article 2. Specifically, the department argued that qui tam relators do not need to be appointed in the manner set forth in the Appointments Clause, nor does the role of a qui tam relator violate the vesting and take care clauses articulated in Article 2. In support, the DOJ pointed out that every court of appeals to address the question has found FCA qui tam lawsuits to be constitutional. But while arguing against the Article 2 challenge, the DOJ did ask the Third Circuit to vacate the judgment against Jansen on the basis that the district court had improperly instructed the jury and ruled incorrectly on a post-trial motion. The DOJ has also asked the circuit to find, if it does not vacate the judgment, that the civil penalty amount does not violate the Eighth Amendment's excessive fines clause. So this is a closely watched case, and briefing is set to continue this fall. And this is obviously a dynamic topic that we're staying on top of.
Right. And Pam Bondi's statement tracks with this administration's stated intention to use the False Claims Act to further its policy goals. For example, in February, Deputy Assistant Attorney General Michael Granston delivered a speech at the Federal Bar Association's qui tam conference and announced DOJ's intention to aggressively enforce the FCA to pursue the administration's priorities. And then in April of this year, Attorney General Bondi directed the fraud section to pursue FCA claims involving what she called radical gender experimentation and explained the DOJ was eager to work with qui tam whistleblowers with knowledge of these sorts of alleged violations. Then in May, Deputy Attorney General Todd Blanche released a memo on the administration's efforts to eliminate DEI initiatives it views as illegal, in part through what he described as vigorous enforcement of the FCA through the use of qui tam lawsuits. And then most recently, in July, the DOJ and the Department of Health and Human Services issued a joint press release announcing the creation of the DOJ HHS FCA working group. The establishment of this working group reflects the administration's focus on the prosecution and investigation of potential healthcare fraud. And in announcing the group, the DOJ and HHS specifically highlighted their commitment to using the False Claims Act as a tool and stated that the FCA is one of the government's most effective and successful tools for combating healthcare fraud.
Thanks. Let's round out this episode with a brief discussion of whistleblowing under the 2020 Anti-Money Laundering Act.
Yeah, so the Anti-Money Laundering Act 2020, or AMLA, created a new whistleblower program, which is administered by the Financial Crimes Enforcement Network, or FinCEN. As originally created, FinCEN was authorized to pay awards to whistleblowers who voluntarily provided original information involving Bank Secrecy Act violations or U.S. economic sanctions. However, following the Russia invasion of Ukraine in 2022, the program was expanded by Congress to include additional sanctions against certain Russian oligarchs. Under the program, whistleblowers submitting a tip on an appropriate subject matter can potentially receive up to 30% of the monetary sanctions imposed by the government. As with the other programs we've discussed, the information must be original and it must be provided voluntarily. Again, as with the DOJ program, it is not considered voluntary if information is provided in response to a government subpoena. The tip must also lead to a covered action, which, unlike other whistleblower programs, in this context means an enforcement action by either the Department of the Treasury or by the Attorney General. FinCEN is still working to stand up the program with formal rulemaking. In the meantime, though, while working towards creating a formal tip intake and award certification system, FinCEN continues to accept whistleblower tips by email. But despite its informal nature for the time being, the availability of this program underscores the importance of strong BSA and sanctions compliance for companies operating in these areas.
Thank you for listening to S&C Critical Insights. We hope you tune in to our next episode in this series, in which S&C partners Camille Shields and Mehdi Ansari will discuss the recently introduced AI whistleblower bill and explore how certain AI whistleblowing violations might proceed under existing regimes. For more information about our practice, please visit us on the web at www.silcrom.com.